Good morning and welcome to our second live Q&A. My name's Sam Roberts. I'm a Principal Solicitor with Roberts, Crosby, Mortensen Lawyers. Joining me today is my colleague Ned Mortensen. Ned's a specialist building and construction lawyer and has 20 years experience in the construction industry before coming to the law, and that included 5 years or 6 years as a building defects inspector, during which time he also appeared as an expert witness in numerous NCAT proceedings. Ned's also an accredited adjudicator under the Building and Construction Industry Security of Payment Act with both Adjudicator Today and the Australian Dispute Resolution, ABC Dispute Resolution Centre. Good morning, Ned.
Good morning.
Today we're going to shine the spotlight on disputes in relation to home building, and particularly what builders should be doing when they're faced with a dispute with a homeowner. Please, we've got a series of questions that we're going to go through today, but we've had a few viewer questions submitted. If you've got questions, submit them and see if we can stump Ned. Ned's our expert on this, so he's going to be doing all the hard work. We might just jump right in, Ned. So what are the most common types of home building disputes?
By far the most common type of home building dispute is a defects dispute, where homeowners are saying or allege that the builder has done work that is not compliant with the relevant codes and standards or is not fit for purpose. Increasingly though, we're also fielding a lot of disputes about increases in time and variations which are not properly due under the contract, as builders try and I suppose grapple with the industry as it's changing rapidly out there and buildings becoming more expensive and more difficult.
And what about delays? I know we also get a lot of inquiries from homeowners complaining about delays and wanting to terminate contracts.
It's very rare that a homeowner should be able to terminate a contract for delay, although they try and do it very, very frequently. In the event that a homeowner is trying to delay a builder's or is trying to terminate a builder's contract for delay, it's probably an invalid termination. They should talk to us quite quickly about that.
Right. And if a builder is facing increasing costs, materials or delays, how do they recover their increased costs of materials and delays?
It depends on the type of contract. Obviously, if you have a cost plus contract, it's very easy for you as a builder to recoup that money. If you have a fixed price contract, it can be much more difficult, although all of the standard form contracts, and by that I mean the Housing Industry Association contracts, the Master Builders Association contracts, the Department of Fair Trading contracts. They're the three most, they're the three most common standard form residential building contracts that we see in use. All of those have provisions to claim costs for certain types of delay, although they all vary slightly in what's claimable and what's not. And to some extent, it might be possible in at least the Master Builders and HIA contracts to recoup the increased cost of materials, although it's much more difficult and it will change on a case-by-case basis. So if you're experiencing additional expense because of delay, particularly delay that's not caused by you, or additional material costs, you should talk to us.
And I guess including some, bespoke special conditions dealing with circumstances that are outside of your control that might be included?
If you have the luxury of starting a new project, we can certainly draft those special conditions for you. I suppose the situation I was talking about is where the contract's already on foot. You're halfway through the build, you're finding that you're struggling to get trades, you're struggling to get materials.
Yeah. And I guess, to what extent could you use provisional sums or prime cost allowances to protect them?
You can use them to great effect, and it's advice that I often give clients that they should do that. Obviously, it can become a negotiation point with homeowners because homeowners like to go into contracts with certainty, but it's my standard advice that they should be using scheduled items to give flexibility in contract value.
It's a two-way street with the builders need to be protecting their own businesses as well, and I think being proactive and making sure you've got contracts that protect you, at least where you've got the right balance, is a pretty important thing to have in place.
Absolutely.
What should a builder do if a homeowner purports to terminate a building contract? We say purport because they don't always get it right.
No, that's right. Homeowners actually frequently, get termination wrong. It's always a difficult situation because if a homeowner is actually purporting to terminate a contract, it's generally an indication that they no longer want to work with the builder. So from a practical point of view, it can be quite difficult. However, it's very, very important if a homeowner tries to terminate a builder that you get legal advice quickly, because there are several rights that can come about an invalid termination. You might be able to, for example, if you're a builder, sue for your lost profit, which is an important right to preserve. And the facts that arise to homeowners purporting to terminate can change situation to situation. So it's really best to get the right advice as quickly as you can.
And I guess the flip side of that is that builders can get termination wrong as well. So I think if a builder's receiving something that purports to be a termination, it's probably best to get some legal advice about whether it's valid and what to do next. And equally, before you go and shoot off a letter or a notice purporting to terminate the contract yourself, get some legal advice, because if you get it wrong, then you might find that you're the one facing the increased cost of the homeowner getting the build finished by someone else.
That's right. So if you're a builder and you get termination wrong, so if you've terminated when you don't have a right to terminate, the homeowner can actually sue you for the difference that it eventually costs them to build their house, less your contract price. So the difference between the price that they had paid you to build it and the price that it eventually cost them to complete the house. And in the fast-moving and ever-increasing costs of building that are happening at the moment, that can be absolutely debilitating for a builder to have to foot that bill. So, very important to get it right. People try and terminate contracts in all sorts of crazy situations that I see all the time, and it really is a last resort, and it needs to be done very, very carefully, and it really needs to be done with legal advice to make sure you get it right, because the consequences of getting it wrong can be catastrophic.
Well, I might make a note. We'll come back to some of those crazy circumstances if we've got time later.
Yeah.
If a homeowner is holding back a progress payment, what's the best way for a builder to recover that progress payment?
The Building and Construction Industry Security and Payment Act is the best way to recover that progress payment. Following the steps in the Act, there's a fast path to recovery of the outstanding money. And if your payment claim is in accordance with the contract and it's fair and reasonable, you'll have no difficulty in getting adjudication for that amount and getting it quickly.
Yeah, and homeowner, the other way or path through that act is through a statutory debt. So
That's right.
If a homeowner doesn't respond to a valid payment claim under the Building and Construction Industry Security and Payment Act,
yes,
then by default they can have a statutory right to payment that can be enforced through the courts.
That's right.
As well as a statutory right of suspension. So if a homeowner is being difficult in making payment, they could suspend the work utilising the legislation and recover payment swiftly under that act.
That's exactly right.
I guess, and that leads to the next question, which is when should a builder consider formally suspending work or terminating a residential building contract?
Whenever there's a substantial breach of the contract by the homeowner, but most frequently that arises from when you haven't been paid. And when you haven't been paid in accordance with the contract, there will be a right arising, certainly under the contract, and probably, although situations may vary, probably also under the Security of Payments Act for you to suspend, with immunity from any consequences or damages that might arise because of your suspension. But again, very important to get that right, because if you get it wrong, you will be liable for damages for suspending without proper reason.
Yeah, and I think if they were sort of refusing access to a site because they didn't trust you to do the works or to rectify work or complete work, what is that a situation we would consider suspending or terminating? Or
well, certainly if the works are still on foot and you haven't reached practical completion and you're being denied access to the works, that's most certainly a valid grounds for suspension. There's another situation that arises that I think you might be hinting at, where you're prevented from accessing site after practical completion to rectify defects. There's little utility probably in terminating the contract in that circumstance. However, perhaps it may be warranted, depending on your circumstances.
If a homeowner's already commenced proceedings in NCAT, which is where home building disputes get resolved, can a builder still utilise the security of payment laws to recover a progress payment that might be outstanding?
Absolutely, they can. So Section 32 of the Security of Payments Act gives a right to conduct actions against security of payment concurrently and sometimes in separate courts even to the action of the homeowner for defects or whatever their action may be. You also have a right to apply for adjudication while the NCAT proceedings are going on. They're completely separate rights. NCAT unfortunately doesn't have jurisdiction to deal with security of payments claims, so you can't have your security of payment matter resolved in NCAT in the same proceedings as the defects. However, you can concurrently, at the same time, run proceedings in the local court or the district court to claim for a statutory debt under security of payments, or probably more suitably in that situation, send the matter to adjudication.
And in what situations, I mean, it sounds like there's a lot going on.
Yeah.
Why would you have them both going at the same time?
Strategy, because if you're a builder and you're successful on recouping money that the homeowner pays you, one of the things that you've done is depleted the homeowner's fighting fund. So you're taking the money that they're spending on suing you away from them and putting it in your pocket to defend their lawsuit against you. So it's very much strategic, but also because basic cash flow reasons in a building company, get that money in as fast as you can, like any business.
Yeah, and I think if you have that enforceable right, then that can be used as leverage to try and negotiate a settlement as well. I mean, I guess the point to make there is that whilst you can have these concurrent matters going on, the rights that accrue under the Building and Construction Industry Security of Payment Act, they're not final. They give you an enforceable right subject to a final determination by the tribunal or by a court.
Yeah, that's exactly right. And there's a provision of the Home Building Act that essentially says that the tribunal's to take any security of payments into account when they're calculating the final payout to the homeowner or builder.
And do you have to wait for NCAT proceedings to be commenced before you can enforce rights under security of payment laws?
No, they're completely separate rights.
Yeah. And in fact, if you're a builder, you'd be looking to utilise security of payment laws as a first step. It's the first thing to look at.
Absolutely. I mean, if time for payment's gone by and you haven't been paid, security of payment laws should be your go-to.
As a builder, what should they do if they receive a home building application form from NCAT? And what is a home building application?
So when a homeowner applies to NCAT for the resolving of a building dispute, so a building dispute is really or most commonly about defects or delay or these type of grievances that homeowners have. They'll make an application to the tribunal. The tribunal will produce what's called a notice of hearing, and they'll send you a notice of directions hearing, which is the first time that you'll appear in front of the tribunal, and they'll attach to the back of that, although at least they should, and they usually do, attach to the back of it a copy of the homeowner's application, where the homeowner will indicate what the dispute's about, how much money they're trying to recover, and why they think they're owed that money. That's all very valuable information, and you should read that, and you should engage with the construction lawyer as soon as you can to get some advice about the homeowner's claim and the veracity of it. Yeah. And also any cross claim or opportunity to recover money under the Security of Payments Act that you might have right now.
Yeah, but the very first thing that you're going to be needing to do is appear at a directions hearing for conciliation to try to resolve it, and it's best to get some legal advice to know what your rights, strengths and weaknesses of your legal position are in that negotiation, or potentially have a lawyer involved in that negotiation. And otherwise, the next steps would be to prepare a points of defence or a points of cross-claim to go in those proceedings. And these are documents that really succinctly set out your legal position and form the basis of the matter moving forward. So
that's right.
Which I think leads into our next question here. Do I need a lawyer to defend me in NCAT proceedings?
Only if you're being sued for an amount that you're prepared to lose do you not need a lawyer.
And in cases under 30,000, there is no right of representation.
That's right. So the rules for legal representation in NCAT are such that parties are to be legally. There's a general rule that parties are not entitled to legal representation. There's an exception in the home building list for matters over $30,000 in value. Nevertheless, you still have to ask for leave. So in layman's terms, you have to ask the tribunal's permission to be legally represented. And really, in the home building list, in claims more than $30,000, that's a very simple process that is almost never denied. But nevertheless, your lawyer will still have to either write to the tribunal or make an application from the bar table on the first occasion to appear.
And I guess whilst the tribunal is kind of a less formal forum for resolution of disputes, and the strict rules of evidence don't apply, the tribunal members still have quite a broad power to make costs orders. So these are orders at the end of a matter where you might have to pay the other party's legal costs, or conversely, if you were successful in defending your case, or you can get a better outcome than you've offered to settle it, the tribunal can make orders in your favour. And when you've got claims that are, often there's significant amounts in NCAT.
Yeah.
Certainly not amounts that you can afford to lose. And the legal costs can, I guess, also be quite significant. So it is really important to protect yourself from that potential liability, but also the potential liability for costs, because you might be faced with a claim for $100,000 or $200,000. And when you add the costs onto that, it can be crippling.
So the maximum jurisdiction in NCAT, well, certainly for the payment of money, is $500,000, and the legal costs that can go along with that can be quite substantial. I recently acted for a builder who I didn't run his claim. He came to me after the other side had obtained judgment in their favour, but he has cost orders against him in the order of a couple of $100,000 on top of $500,000 that he has to pay out.
Yeah.
So that's very substantial, and it can happen if proper care isn't taken. It can happen. So the key takeaway is any claim that's over $30,000, generally the unsuccessful party will be required to pay a significant portion of the successful party's costs.
Yeah, which is why it's so important to get proper legal advice, try to resolve disputes early, and or put forward a fair and reasonable offer of settlement that hopefully is going to result in a better outcome than the other party will get in the proceedings, so that you're in a position then to ask for your costs to be paid despite still having an order against you.
That's right.
As a builder, when should I bring a cross claim in NCAT?
Whenever you can. So whenever you typically
nearly always.
Yeah, nearly always. The most common answer to that is when you owe money under the contract. In almost all building defect disputes that have occurred towards the end of the build, homeowners tend to withhold money. Quite often they withhold the last progress payment when there's no contractual entitlement to do that. And in that situation, you should be making a cross claim immediately.
And if you had rights, we talked about utilising the security of payment laws to recover a progress payment. So in that situation, you could put your cross claim in NCAT, but at the same time looking to enliven a claim under the security of payment laws.
Yes.
And just to look at that, what should builders be doing to be able to position themselves to utilise security of payment laws, if and when they need to?
The first thing is to learn more about how security of payment laws work, and there's lots of information on our website about that.
There's a guide here as well.
Become familiar with the laws, then use them to your advantage. So what you need to do is prepare payment claims that will trigger the mechanism of the Act. So they need to be payment claims that are made in accordance with the contract, or on or from the last day of each month that you do work, and they're to identify the work, they're to identify an amount claimed for the work, they're to be endorsed that there's a claim made under the Building and Construction Security of Industry Payment Act, 1999, and making sure that your claims are compliant. So then, when you need to rely on the security of payment laws later, it's a very straightforward process. It's not irretrievable if you haven't done that and there's a dispute. For example, if you come to me and you haven't done that, the first thing I'll do is reissue your most recent claim and make sure it complies with the Act. That's less than ideal. The ideal situation is that you're aware of the Act, you know how it works, and you are using it.
That's right, because if you are going to see Ned or another lawyer around these issues, it's probably the case that the home builders are also getting legal advice and they'll be ready to respond to a payment claim. I mean, the Act is fantastic, or the Security and Payment Act, in resolving it through adjudication or through the statutory debt regime. But it's always good to get those up and avoid the need to even go through adjudication in the first place.
Yeah, the other thing I'd say is, given that the Act is applied to residential buildings since the 1st of March in 2021, it's incredibly underutilised by home builders, and it could be used by most home builders to their advantage much more. You know, it's worth learning about the Act and how it works, and you know, if you're unsure, talking to a lawyer about it to make sure your payment claims and your invoices are done correctly, because it's such a powerful Act to ensure that builders' cash flow is properly sustained.
And I think so. That law change came in, as you said, on the 1st of March 2021.
2021, yes.
And prior to that, you know, it didn't apply to homeowners unless who were going to be owner occupiers. What do you think is the rationale for changing?
Well, I think the object of the Act has always been to make sure that builders get paid, and residential builders are a very large part of the building economy, and particularly, I think, in the last 5 years or so, the industry has changed substantially, and I think the government just made a policy change to ensure that these residential builders are included, to make sure that they get paid like everybody else.
Yeah, I think it's a significant change that it now does apply to contracts with mum and dad homeowners. I think part of the reason why there was a carve out was to sort of protect these mums and dads from, you know, unwillingly ignoring a payment claim and suddenly having this statutory debt or depriving them of rights through NCAT. But it is an important change, and it does add significantly to the way builders should be resolving disputes.
Yes. There's a regulatory requirement when a homeowner enters a residential building in a contract now that the builder actually provides information about the Act. Fair Trading have a printed information booklet which must be stapled to the back of the contract. So homeowners these days are probably on notice of what they need to do, and you know, just like builders, they need to be aware of the Act.
Yeah. Now, if I'm a builder and I've got a difficult homeowner, or they're depriving me access, or they're not paying, you know, what's the first thing I should do?
Call me.
And how are you going to help me? And how much do you charge?
A free case evaluation is a 15-minute free case evaluation. How am I going to help you? Well, generally the first thing is to evaluate the circumstances, and in most cases write to the homeowner and let them know that you're represented, and point out the rights that you have as a builder to the homeowner, and encourage the homeowner to make a resolution.
Absolutely. And I think, you know, an experienced building construction lawyer getting involved at an early stage, you know, can really make a big difference. If someone isn't sure what they're doing, or giving you poor advice about terminating a contract when maybe your rights to termination don't exist, that can create an even bigger problem. So getting good advice, and we do offer a free case evaluation.
Yeah, there's something to be said for that, in that my world is divided into 2 types of lawyers: dealing with other building and construction lawyers, and dealing with general practitioners. General practitioners who don't practice in this area a lot tend to give some reasonably poor and costly advice a lot of the time, just because it's a very specialised area of law, and you know, you see them terminating in situations, or attempting to terminate in situations where there's no right of termination, enforcing rights that really aren't rights at all. You know, whether it's me or another specialist building and construction lawyer, that's really should be the go-to for builders, rather than, you know, whoever did your conveyancing and wills.
Absolutely. Yeah. Well, I think that's all the questions we've got. Do we have any other questions?
No questions at this time.
No questions. If you have any other questions, please feel free to submit them. We'll get back to you with some answers. Otherwise, thanks so much for your wonderful help, Ned, and thanks everyone for joining us this morning.
Thank you, Sam. Thank you, everyone.